Hello everyone and welcome to today's webinar. It's great to have you all here and join us this afternoon. Today we're going to talk about maximising intergenerational wealth transfer. My name is Nicola Beswick. I'm a Senior Financial Advisor here at FMD Financial, and I'm joined by a colleague of mine, Michael Russell.
Hello and welcome.
Michael's another financial advisor here at the company as well. So as I noted before, today we're going to talk about maximising intergenerational wealth between particularly generations, as we've all worked so hard to get to the places that we are. Now, before we do get into the presentation, a couple of housekeeping things. We will have time for questions and answers at the end of this presentation, and you'll be able to see a Q&A box. So please type in any questions that you may have, and we'll get to them at the end. Now, one thing that we'll want to address before we get into the presentation is a couple of myths that surround the estate planning side of things. The first myth that we commonly see is that we can worry about wills and estate planning documents when the time really is there for them to be needed. Unfortunately, this is a really complex aspect for people to get through, and some considerations do need to be taken into account. Often you need to enlist professionals such as advisors and estate planning lawyers in particular, and you may want to get your family involved with any decisions that you may want. If you're trying to get these documents in place as someone's lying on a hospital bed or so forth, it sometimes can be rushed, and you may not necessarily get the exact wishes of yourself or your loved one conveyed. So it's one thing I think we see quite a lot of is people rushing into these things and not necessarily getting the outcomes, both financial and medical, for what they really want.
Yeah, and that leads us into myth number 2, which is you can do a DIY will kit and you don't really need a lawyer. While these documents, and the most common one is probably the post office will, well, there's a lot of online wills as well. They're legal and they cover the most common situations. It's often the unforeseen issues and the potential complications that you may not have even thought of that need to be addressed. So if you've got one of these documents or even an old will, it's a good idea to get a professional to cast an eye over it, and they can let you know whether it's adequate and it's suitable, or whether you need to have it redrafted. And often this can be a lot less costly than having a brand new will drafted from scratch.
That's exactly right.
Your FMD advisor can work with your lawyer to make sure that the key financial aspects are addressed, such as protecting your wealth and also ensuring your assets are distributed exactly how you want them to be. Estate planning is one of those things in life that there's no substitute for good professional advice. If you don't have a solicitor, speak to your advisor, who can put you in touch with a good estate planning lawyer.
And that brings us to a third myth that we see all too common, is that estate planning is only for wealthy people. Unfortunately, it doesn't matter how much money you do or don't have in your eyes. Everyone needs to make sure that they have their affairs in order. Your estate covers a range of different assets, including your superannuation and investments outside in your personal name. But things like your family home, you may want to consider what you want to happen with that. And if you've got special needs for any particular areas that you may want to include in your will. So it's really important to think about the hard work that you've been through to create the wealth that you have currently got, and to make sure that you can maximise the plans that you wish to undertake as well.
Another myth is that our loved ones know us well enough to know exactly what we'd want. The reality is that many families don't talk about these issues. Death and money are two topics which are avoided in a lot of families to discuss. The reality is they're tough topics to discuss, and they're just not brought up. They're confronting often, and it can often be sad. We're talking about death and passing away. This can leave those closest to you very uncertain about what you might want to happen in a given set of circumstances, and it can also put a lot of lot of stress on the family in terms of dealing with something at that point in time where something like an accident, illness or death can come very quickly. So getting your wills and estate planning in order is really important to make sure your family doesn't face this burden, which can cause long-term trauma and often can cause division in what were quite close families after the passing of a loved one.
Yeah. So for the next 30 minutes or so, we're going to really talk about this topic and touch on some of the complexities that surround some of the most common and financial decisions that people do need to make throughout this process, and really highlight the value of getting good financial advice and the outcomes that can lead to, particularly to maximise the transfer of wealth between generations, because that's what we're here to listen to today, is how to get the best outcomes for transferring wealth through the generations.
All right, we'll start the presentation off. We'll be back at the end of the discussion to answer any questions that might arise. So we'll start it off now. Key financial and legal considerations. This is the first slide we're going to cover. And really with estate planning, we've got the big difference, I guess, is one, we've got assets inside of super and we've got assets outside of super. And then there's different rules that apply to both. Non-super assets, the big thing there with non-super assets is the ownership structure, whether it's a joint ownership or in terms of joint ownership, whether we have tenants in common or joint tenancy. They're the two big differences. Just to give you an idea how it both works, the usual scenario is with the family home is what we call joint tenancy, and survivorship rules come in. So that's where if we've got a husband and wife and the husband passes away, joint tenancy will mean that the asset just automatically transfers to the surviving spouse in that scenario. If we've got a situation where a property or an asset has multiple owners, say for example an investment property, in that case the most common ownership is tenants in common, and in that case we have a situation where the asset is divided according to the ownership. So if someone owns 50%, then that 50% will be dealt with as per in their will or their estate, and the other part will be the other person's to deal with. That's assets outside super. Super gets a little bit more complicated.
Yes, it does.
Yeah, and with super, we have an extra layer of administration being the trustees of the super fund. And they, while we have an option to nominate a beneficiary inside super, there's different layers of strength, I guess, in terms of the nomination. We're big advocates in this office of binding death nominations.
Yeah.
And the reason why we prefer the binding death nominations is it just gives an added layer of protection in terms of the wishes being carried through of the person making that nomination. The trustees of super fund do have discretion to alter the nominations and the beneficiaries. So if you know what you want to achieve, the strongest way of doing that is with a binding death nomination.
I guess one of the really important thing for people is also, when you fill in these nominations, is making sure you nominate the correct people as well. And there are particular rules and areas around that, and that's probably very important.
Yeah, I don't think this is clearly stated on superannuation forms when you nominate a beneficiary. It just says nomination. You need to put the details of the person you're nominating, or you can put your estate and a percentage. But probably more important is who can actually be nominated.
Exactly.
So, for example, your spouse can definitely be nominated, children can be nominated, but we can't nominate siblings or parents unless they're a financial dependent.
And that's probably a big trap that we see a lot, doesn't it?
Yeah, well, effectively means that the nomination is invalid.
Exactly.
Yeah.
Exactly. And I know time and time again I see that, particularly with younger people who may not have children, they want their money to go to their parents, but they don't actually live with their parents anymore, and that's always a very complicated scenario to work through. Yeah.
So while it is simple in a lot of ways, nominating a beneficiary in super, it also has its pitfalls as well. And just getting some advice around that, I think, is essential. The nomination of beneficiaries gets even more interesting, perhaps, when we have split or blended families, Nicola.
It is.
And
yes.
and you know of an example where there's been stepchildren, etc.
Yeah.
And do you want to just tell the audience how that works?
Of course, and I think this is probably something that's really important is if you have adult stepchildren, and I'll use my example for as a way to explain this. So my parents are separated and my dad's remarried, and my stepmum, who's only related to me through marriage, could potentially have me as a child of the member because of that step relationship on her beneficiary nomination. However, if something happened to my dad and she was still alive, I would be no longer considered a child of her and unable to be technically nominated as a child of that person. So the easiest way to cover that off is generally through nominating someone through your will. And that's where coming and talking to someone about what you want to do from your estate plan wishes becomes really important.
Tax considerations. When we're talking about, we'll go back to outside of super again now. When we're trying to divide an estate equally, perhaps amongst children, sometimes might be one or two properties involved, and you might think one property could go to son number one and the family home could go to the daughter, for example, and that the value could be of equal sort of in total.
Yeah.
But one of the big problems can be tax. The investment property has capital gains tax, where the principal place of residence in most cases is tax-free. So that can create an imbalance. So that's something else to take into consideration when we're talking about estate planning and making sure we get the actual end result delivered as we wish.
And that's really important, and that's ultimately what we're talking about here today is maximising the wealth transfer from, say, for example, parents down to children. And it's not just getting the appropriate documentation in place, but taking into account the tax considerations for multiple assets as well.
That brings us to our next topic, and it is what happens if you do nothing?
Well, this is actually really important because we all think we've got time before we can put our affairs in order and make sure we've got things sorted. But, you know, it's not that simple because we don't know generally, unfortunately, when something might happen. And depending on what type of assets you have, so super versus non-super assets are treated differently. So we'll cover off non-superannuation assets at the moment. As you know, a will dictates something from a non-super asset perspective in terms of what will happen to those assets, you know, cash in the bank, any investment properties, personal held shares and so forth. A will is great, and we should highly recommend that you need to get that done through the appropriate legal professionals to do that rather than trying to do your DIY more to save complications. But having that in place allows your wishes to be fulfilled in terms of what you want to happen with those assets. If you don't have a will, however, this is where it gets complicated. Your estate is determined by a magical formula governed by the state in which you live. So, for example, the state of Victoria will go through a complete run-through of, you know, do you have a spouse, do you not, do you have any children, and so forth. And they will actually assign a particular percentage to each of those individuals depending on their relationship. That might not be exactly how you want your money to be dealt with. So really important that you look at getting a will in place. The other thing that is really important from an estate planning side of things is power of attorney. Now, power of attorney allows you to have someone give a say in terms of any situations when you're incapacitated, generally, to do so. So, for example, medical and financial power of attorneys are the key ones.
And the third one is lifestyle.
Exactly.
Yeah. The lifestyle and the financial We can have alternate or joint power of attorneys.
Yep.
Where the medical, I believe you can only have one.
One.
Yeah.
Yes.
What's the reason for that, Nicola?
I think the reason for that is more to make sure you're not getting conflict with different individuals wanting different things.
And that was my understanding as well. I think it's often with medical, things can be time critical.
Correct.
And we can't go to, a panel of joint power of attorneys to get an answer. We need an answer quickly. So that's why the medical one we just have, and that's often not done properly, that one, unfortunately, where the financial and the lifestyle, well, then we've got some more time on our hands. We can, consult with the broader family to get that decision right.
Exactly. But if you don't have those documents in place, this is unfortunately where I've seen a lot of things go terribly wrong. These documents allow, particularly children, for example, they're the main nominees that people have, and they know what your wishes are. However, if you don't have them in place, you have to go through VCAT.
Yeah, and I think one of the most common reasons that they're used is dementia. As people age, their capacity is reduced, and when their capacity is already on the way out, there's real issues in getting those documents put in place, isn't there? There is, and getting them done sooner rather than later foregoes a lot of that heartache. I think the key message is to get them done and get them done early. Yes. Yep. If there's anything that I want you to take home out of this is get your will and power of attorney documents in place, or start talking to someone that can help you. Regardless of everything else that you hear about today, make sure you do that, because it is one of the, although horrible things to try and do and work through, it is also probably one of the most important things to do. Exactly. Yep. So superannuation assets, Michael, you already covered off this a little bit earlier in terms of what happens with those assets, and it is coming down to the trustees of the superannuation fund and how your nomination is put in place, whether it's binding or non-binding. Ultimately, they're the people that have direct say, but those nominations help them make decisions once you pass away. So it's important to make sure that you have those in place. Particularly be careful around timing as well. A lot of account providers have limits where they only last for 3 years and you have to redo them. Some are non-lapsing. So that's an important part of what we do as well, making sure that they're important. Yeah, I guess it's really just getting all your ducks in a row, both outside of super, inside of super, because it all comes together in the end. It does. And the goal at the end is to make sure that your wishes are carried through. Yep. Exactly how you want them to be. Yep. Yeah. Yeah, that's exactly it. Now, one of the this is the fun part that I think about financial planning and what we can do, and this becomes what people may pay from tax perspective if the money's going to a non-financial dependent. Now, this you may have heard from your advisor is the percentage of taxable and tax-free balance within your superannuation. And if that's getting passed to, say, your adult children, they are taxed 15 cents in the dollar or 17 cents in the dollar, including Medicare levy surcharge, on that taxable component within superannuation. There are I call them fun things that advisors can do to increase the tax-free, so the amount that people don't pay tax on over time, as dependents. But there are specific rules and conditions around undertaking these strategies as well. So if you are in a position where you may think you could do it, I would strongly suggest bringing it up with your advisor, particularly because it can make a huge difference to what ends up being paid to your estate as well. I've got one little example there in terms of doing what we call a recontribution strategy, where we move money out of super
into your personal name and then put it back in. And the example that you can see there on the slide is we start with a taxable balance of someone with $500,000. Now we can take, assuming that all the other conditions are met, $300,000 out, put that back in, and that changes the percentages. So all of a sudden, that 500 complete taxable money that would have incurred about $85,000 worth of tax if it was all paid to dependents, that reduces the balance quite considerably that they ultimately end up with. If we do this recontribution strategy and we end up with a taxable balance of $200,000, even though there's still $500,000 in there, that decreases the amount of tax down to $34,000.
Yeah, and provided this strategy is taken up relatively early,
correct,
we can do this multiple times.
Exactly.
Yeah. And I think one thing we've introduced here at FMD with our review reports is we're now showing, in most cases, the taxable and non-taxable components each year. So perhaps that's something you can raise with your advisor. If we don't bring it up, just ask them about the tax components and what can be done potentially with that. It's not something everyone can do because you need to meet the eligibility criteria.
Correct.
And so that is something that can make a big difference to the end net amount that's paid to your beneficiaries.
Exactly, and that's exactly what particularly a lot of people have worked really hard to achieve good superannuation balances, and they want to pass on as much as possible to whoever. And this is one thing that I personally get way too excited about whenever I'm talking to people, but that's the...
Yeah, it's much better off in your beneficiaries' hands than in the hands of the tax office.
It is, isn't it? Yes. So what are some of the myths about estate planning, and what is really important and what matters?
Well, to me, the key, most important thing with estate planning is to actually do something.
Yep.
That doing nothing seems to be a very common approach.
Yes.
So if I can be an advocate of anything, it's to get something in place, get the ball rolling, initiate that conversation with a solicitor, initiate the conversation with your financial advisor, initiate the conversation with your family. Money and death are probably two topics that most of us like to avoid talking about. Yep. They're uncomfortable. They make us feel uneasy, and it's not generally something that a family will discuss.
No.
So I think having a discussion with your family, making it known what you're trying to achieve, and conveying that to the beneficiaries prior to something happening is a really good starting point. And then, of course, getting the right advice, seeking out assistance from your advisor, from your accountant, and from your solicitor, and getting all your ducks in a row. Three key points, I think, with what really matters are perhaps making a decision about even distributing assets early while you're still alive. A big positive or a big benefit of that is the fact that you actually get to do exactly as you wish.
Yes.
You're not relying on a piece of paper that's been written down. You can actually do that. So that's a good way of doing things. There are pitfalls such as the kids perhaps not looking after you, putting you into a cheap retirement home and forgetting about you. So there is other things to take into consideration, but that is one way, and sometimes it's utilised as a way to perhaps maximise settlement benefits and things like that, although there is waiting periods and so forth.
Exactly.
With that. So it's, there's catches with that. The second would be the future needs of the beneficiaries. So often grandchildren's education, it could be one of your children doesn't have as much income earning capacity as the others, and you want to make sure they're looked after. So getting that into the will early is a good way of doing it. And another key thing, or the last key thing, is intended beneficiaries.
Yes, that's important.
Yeah, ex-spouses of children, previous relationships, perhaps someone who hasn't done the right thing by you during their lifetime, and you want to make sure that they're not given as equal proportion of the estate. Getting these things down and in your will, having a discussion with the solicitor, they're really important to make sure that your wishes are carried through.
I think that's probably a really important topic, is because we haven't touched on, and we won't go into depth about this, but it's people that can challenge your estate once you pass away. Very complicated, and like I said, I don't want to go through that, but that is a key reason for maybe looking at what you want to do. And can you do some of these asset distributions prior to your passing or your collective passing if you're a couple? I guess that brings us to our next topic, some of the pitfalls that we've seen through our professional journey.
Yeah, we have seen quite a few.
Yes.
Nicola, do you want to maybe start off with a story that you've got? Perhaps things haven't gone to plan or haven't quite worked out as intended.
As intended. Well, this the first, what I call war story that I've come across was to do with a stepchild. This couple, Morris and Dee, Dee was the surviving spouse after Morris passed away, and she unfortunately had cancer that came back and was quite aggressive in nature. Through Morris's passing, she had actually inherited all of his wealth through superannuation, and his wishes prior to passing, and this was articulated in his will, was that he wanted his daughter to receive some of the money in addition to the 3 children that Morris and Dee had. Now that does raise a little bit of complications, particularly when we look at some of the assets that she had. She had 2 pots of money, so to speak. We had superannuation as well as money in her personal portfolio. And it really became a question of how could these different types of assets be passed on effectively, and how to take into account the distribution of money that Morris actually wanted at his passing, particularly because Dee's estate didn't actually take into account that distribution to the 4th child that was part of that family unit. One of the unfortunate things that I saw through this situation was that daughter actually start challenging potentially what could be hers, not only what was her father's, but also what both Morris and Dee had collectively earned and had from an asset base. So she was all within her rights to challenge that and go through it. The fortunate outcome with this story was after they sat down with the 3 children and the executor of Dee's estate, came to some kind of agreement, so that actually avoided a lengthy...
That was fortunate.
Yeah, very fortunate, and you could quite easily see how that could have turned very nasty very quickly.
I've got one. Mine's actually an unfortunate one where I had a client who I think he'd been a long-term client, maybe 10 years plus, and he was fortunate or unfortunate enough he was a widower, and he'd met a lady friend through the bowls club, and they developed a friendship, and it became more than a friendship, and it got to the point where they were spending time at each other's houses, and then Bill came in for a review and said he was going to change his will and put Ruth down as the beneficiary, and he went and did that. He had his will updated. Not long after that, Bill suffered a fall, and he had to spend some time in hospital, and then he had a mini stroke after that. And during that time, it became evident he wasn't able to stay in his own house. He needed to be moved into aged care, which he did. He went in there. He had fairly frequent visits from Ruth to begin with, and then he wasn't seeing much of Ruth at all while he was in the aged care. He wasn't happy with where he was in aged care and thought he would move. Ruth advised him that wasn't a good idea. It's too expensive, despite pretty rough conditions in there or conditions he wasn't happy with. So at our next review, Bill said that he was thinking about changing his will. And he met with the solicitor to get the will changed, but unfortunately between that meeting and getting the will finalised, he had another stroke, and therefore he didn't have the capacity. He saw a geriatrician to get the sign-off to say he had capacity, and they wouldn't give it to him. So effectively he was stuck with that will that he didn't want, and subsequently passed away not long after that. So going back to that, what's the key thing? It's act quickly. With estate planning.
I think that really brings it home, doesn't it, in terms of really some of the unfortunate and unintended consequences that can come out of not having your affairs set up and thinking about what you really want to do with that.
Yeah. Did you have any other ones, Nicola?
A single lady, Glenys, and she has, this is very much a very extreme situation, but something that I think is really important to think about. She's got 4 children. Her asset base, superannuation, family home, and her funds, that's what's going to be distributed. And on face value, 4 children, equal distribution. Really great, isn't it?
Seems fine at this stage.
Seems fine at this stage. But what about their specific situations from a family perspective? Let's look at potentially this side of things. Dave, who's one of the children, he runs his own company. And if he ends up with money in his name from Glenys's estate, that might be impacted from a creditor's perspective. That might not reflect with what Glenys would want from an estate planning perspective. Her other child, Samantha, may be in receipt of the disability support pension, and we know that can be asset tested. And if they unfortunately receive assets, then this could impact that entitlement. And then what about Anne, who might be going through a divorce and the money from an estate being part of that matrimonial pool that then the estranged spouse that Anne has, that could potentially be impacted.
If you defer that'd be good.
Yes. Now, this, as you probably guessed, is not actually a real person. This is a very fictitious situation, because it would be really horrible if someone had 4 children and they were all going through unfortunate things like this or had these consequences. But it really does highlight some of the situations where...
You've got one more child there.
I know.
Tony. Now,
do we actually know anything about Tony? No.
We don't.
We don't. So we don't actually know how Tony's inheritance could impact him. And I think this is probably one of the key things where, us as financial advisors, you may know a little bit about half the children, but not the other half because of issues there. That could impact how you, as a parent, may want your money to be passed on. But if the child's situation means that certain other considerations need to be taken into account, then that helps you fulfill your wishes as well. So it's really important to cover off that. Now, that is extreme and just can highlight some of the issues.
But even just one of those complications is enough to complicate things.
Exactly. And when you think about what you want to ultimately achieve, and the reason we're here today is to talk about transferring wealth from one generation to another, it's not only what you can do from your situation to increase that asset or the value of the assets being transferred, but it's the situation in which the child can benefit the most from receiving that money, and understanding their specific situations can also come into play as well. Transfer balance cap, as we know, well, financial planners, the lovely things that we do, this is the amount that people within the pension phase can have tax-free. Once upon a time, up until recently, you could have, once you reached the qualifications for starting an account-based pension, you could have all of your money in an account-based pension, which is effectively tax-free from an earnings and a capital gains tax perspective. Rules changed, and now we can collect, people can only have up to $1.6 million. Now this is being indexed to $1.7 million from the 1st of July this year in that tax-free component. Any excess can, particularly if you start a pension, can remain in superannuation, but has to stay in the accumulation phase. Now, that's all very well and good, particularly if there's two people. And I've got an example there of John and Mary with respective pension and accumulation balances in their superannuation account. However, when someone passes away, for example, John, we then have to work through what happens with that superannuation balance that he has, remembering that Mary can only have $1.6 million in the pension phase, and she's already used that. So what do we do with that? Fortunately, because she had a reversionary, he had a reversionary nomination in place to highlight his wishes to have his money passed to her, that meant she had time to before she had to make any decisions. Very key important detail there, if you don't have a reversionary beneficiary nomination on pensions, then you have to deal with that pretty quick smart, which can be quite a traumatic experience, particularly when you've recently lost a loved one. So we have to address this because that's particularly important. We've got asset bases of just over 1.6 million for John. She's already got 1.6 million. So what do we do with that? The key thing in terms of the strategy that was really important was looking at how do we maximise retaining the most in superannuation. And with her, one of the great things that we were able to do within the situation was, in order to retain what she had in superannuation already with that pension amount and accumulation, in order to receive John's benefit, we technically, well, the official term is roll back her pension amount into the accumulation phase. So that sat within her accumulation account. And then we were able to receive John's pension amount as a pension into her account-based pension. So she effectively started a new pension with John's money, while retaining what she had in superannuation through commuting it back to the accumulation. That's really great from a tax advantage perspective, because if you imagine how much money that might be taxed in someone's personal name,
it'd be huge.
It would be huge.
Yep.
And the unfortunate thing, well, the fortunate thing was that meant that only that small amount that was in John's accumulation component came out of the superannuation environment, because that couldn't be retained by any way. Much better than having 1.6 million coming out of super and having been taxed.
Definitely.
Yeah.
And there's also just the convenience of it as well, all being retained in super, and she just recommenced the pension payments perhaps similar to what they were before.
Exactly.
Yep.
Exactly. And that becomes, ultimately, it's about choice and flexibility. And I think that's probably the part of the role that we play as advisors to people when we're going through the process of these situations that we're in. So I think that's really wraps up, I guess, couple of very extreme examples and a couple of real life examples in terms of what we've seen with the pitfalls and potential pitfalls of superannuation and estate planning.
Yeah, I think hopefully it demonstrates the value of getting advice and also getting your affairs in order. I think that's the recurring theme here is don't do nothing.
Exactly. And that's it really for everyone who's taken the time to listen to us. I think we've given everyone a little bit of homework to look at in terms of estate planning, talking to your children, for example, in terms of what your wishes are from a planning perspective, talking to the professionals that you have around yourself, financial advisors, accountants, solicitors, and have them understand what your wishes are. And if there's anything more that you could do now before you pass away, from making that transfer of wealth between generations happen in the least tax effective manner. Yes. Yeah. Thank you, everyone, for staying in and listening to us talk. I hope you enjoyed that and got some useful tips from the conversation that we had. As indicated earlier, we've got some time for 2 to 3 questions, so please pop any comments, questions into the chat box, and we'll answer them. I can see a couple have come through already. I've got one question around power of attorneys.
Yeah, maybe I'll answer that one. This question is around power of attorneys and whether they're accepted in different states. So is a Victorian power of attorney accepted elsewhere? I don't know the full answer. I know that most power of attorneys are accepted in most states, not everyone, but most. And I think the Victorian rule is if the powers could be given under Victorian law, well, then they will be accepted. The other questions we've got there, we've got one from Tom who says, how can I bring up will/creation modification with my parents without coming across rude?
That's a very good question, and I think answering that depends on the personalities and the dynamics there. I've normally talked to people around, talking about other, like family members that they know, and addressing that and using that. I think that has always been the way to have the conversation.
I think you bring it up softly. I don't think there's a right or wrong answer in terms of how to bring it up, but I think it's a tough conversation for both sides, and it just needs to be done. So just throw it out there, Tom. Looking through the questions, we've got one more we can do here. One from Jane, which is, most of my estate will go to charities. Are there any particular pitfalls to be aware of?
I think that's fantastic that you're considering that and as part of your estate planning side of things. I think the pitfalls is very much making sure that you've got that covered off in your documentation. If there's anyone that may be entitled to any of your estate that could potentially challenge it for whatever reason, that may be a particular complication that may come up. And making sure that the charities that you've addressed continue to be right as well. Keeping your affairs up to date and reflecting current wishes is an important piece of the
I think it's essential in that scenario to seek professional advice, because it's the unintended beneficiaries perhaps that will be the hardest thing to deal with in that case, where intended beneficiary is the charity. Anyone who thinks they may have a claim on the estate will need to be addressed in that will, so that that's not where the funds or the assets end up going. that's probably all we've got time for today.
Yep.
Thank you very much for joining us today and sticking through the presentation. If there's any more questions that come after this presentation that you think of, send it through either to your FMD advisor, or you can send it through to us. We'll have a screen here where we can see the questions coming through the next little while. Otherwise, thanks for joining us and have a great day.